at the onset of the Indian Maternity Act Amendment 2017. Maternity Benefit Act in India. The Indian Maternity Benefit Act of 1961 was amended in 2017. It is meant to regulate the employment of women before and after childbirth and provides maternity benefits. This report reviews the employment conditions of pregnant women before the 2017 amendment as evidenced through important court cases. Categories of maternity benefit: court cases prior to 2017, termination of employment and payments on account of maternity, denial of regular leave on account of maternity, illegal service rules. Index of court cases with categories: termination of employment and denial of payments. 1. Air India vs Nargesh Mirza and Organisation, 1981, Supreme Court of India. 2. Bombay Labour Union vs International Franchises Pot Limited, 1965, Supreme Court of India. 3. K. Chandrika vs Indian Red Cross Society, 2006, Delhi High Court. 4. Ratan Lal and Organisation vs State of Haryana and Organisation, 1985, Supreme Court of India, Denial of Regular Leave. 5. Tata Tea Limited vs Inspector of Plantations, 1990, Kerala High Court. 6. Bisha vs Presiding Officer, Labour Court, Coimbatore and Organisation, 1977, Supreme Court of India, Illegal Service Rules. 7. SMT Neetu Chaudhary vs State of Rajasthan and Organisation, 2005, Rajasthan High Court. 8. Vandana Kandari vs University of Delhi, 2010, Delhi High Court. Air India vs Nargesh Mirza and Organisation, 1981. Nature of petition: in this case, many air hostesses of Air India sue their employer because of a company rule in which a hostess would be fired or terminated if she became pregnant. Court order: the court ruled that this provision was unreasonable and violates Article 14 of the Indian Constitution. Ratan Lal and Organisation vs State of Haryana and Organisations, 198. Nature of petition: in this case, government-employed teachers in the state of Haryana were unhappy because they did not receive many benefits, including maternity leave and other maternity benefits. Court order: the court mandated that maternity benefits and leave be given to the teachers of Haryana. K. Chandrika vs Indian Red Cross Society, 2006. Nature of petition: in this case, the petitioner's employment at the Indian Red Cross was terminated during her maternity leave, and she was also denied reinstatement and benefits. Court order: the court ruled that her job was terminated illegally, and ruled that the petitioner must be given her position back. Bombay Labour Union vs International Franchises Pot Limited, 1965. Nature of petition: in this case, an employment policy of International Franchises Pot Limited stated that upon marriage, a woman would be terminated from her job within the company. Court order: the court struck down this rule because they noted that there was no indication that the performance of a married woman would be different than that of an unmarried woman or a widow. It ruled that there is no justification for a rule of this kind which requires an unmarried woman to give up service immediately she marries. Bombay Labour Union vs International Franchises Pot Limited, 1965. Nature of petition: in this case, the Inspector of Plantations stated that many practices of the defendant, Tata Tea Limited, were unconstitutional. Court order: the court stated that if a woman is currently under maternity leave, then her employer cannot make her work on holidays. In addition, the court held that the money a woman makes under the National and Festival Holiday Act cannot be combined with the money she is entitled to under the Maternity Benefit Act. Bisha vs Presiding Officer, Labour Court, Coimbatore, Organisations, 1977. Nature of petition: this case involved a discrepancy of whether Sundays, on which day workers are not paid, could be excluded whilst calculating the mandated government maternity benefits paid to her in the time period of 12 weeks. Court order: the court ruled in favour of the petitioner, and ordered her company to pay her for the 12 Sundays in her maternity leave. SMT Neetu Chaudhary vs State of Rajasthan and Organisation, 2005. Nature of petition: the petitioner in this case was a government worker who was denied maternity leave based on the account that she was on a contract-based consolidated salary, and was therefore not entitled to maternity benefits. Court order. The court determined that one cannot withhold maternity benefits to female employees based on the nature of their employment. Vandana vs. University of Delhi, 2010. Nature of petition. In this case, the University of Delhi reprimanded the petitioner on the grounds that she did not attend classes. However, at the time she was in an advanced state of pregnancy and unable to attend the classes. Court order. The court ordered that no college or university can hold it against a woman to not attend classes if she is unable to attend due to pregnancy. Conclusion. The many landmark court cases reviewed in this study clearly reveal the trials and discrimination that Indian women went through prior to the 2017 amendment. It is commendable that the Government of India recognized the fact that the MB Act 1961 was sorely overdue for an overhaul, if India were to achieve its mission of improving global ease of doing business rankings, in which labor rights are an important parameter. Any question, ask C-Quel.